Do you know someone in foster care? Have you been in foster care? Do you have a child in foster care? Are you a grandparent or relative caring for a family member? Are you considering becoming a foster parent? Then tune in every Wednesday at 3 p.m. to Fresh Start Today on WNOV 860 AM to engage in thought-provoking conversations with families and providers about child welfare services, both locally and nationally. Together, we can save our children. Good afternoon. You're listening to Fresh Start Today. I'm your host, Jermaine Reed, and I have in the studio with me some great individuals. So glad to see the blacksmith himself, Dr. Ramel Smith. Good afternoon, Mr.
Always
Dr.
good to be on Fresh Start, always.
Man, it's great seeing you. It's really beautiful outside. Then we have Sean Roby, our master level social worker. He's here, our co-host. How are you doing, Mr. Roby?
Good afternoon, everyone.
You know what? And we are so proud to host today's segment entitled, what's today's day? Ask the Judge with Judge Rebecca Bradley. Good afternoon, Judge Bradley.
Good afternoon. It's great to be here.
You know, I just want to take a little time to introduce our listening audience to you. Some may be familiar with you, others may not. But can you talk a little bit about your career in behind the benches, in the courtroom? What has your experience been like?
Sure, you bet. I have been on the Wisconsin Court of Appeals newly this year, but before I served on the Court of Appeals, and I'll explain a little bit more about that, I served in Children's Court in Milwaukee County for 2.5 years. And I was a Milwaukee County Circuit Court judge, and I presided over cases involving CHIPS, children in need of protection or services, termination of parental rights, and guardianship cases. Before that, I was in private practice for over 16 years. Now that I'm on the Court of Appeals, I hear appeals from the trial courts of Milwaukee County in all areas of the law.
Wow. So you've done a lot of work for the last, how many years you said?
I've been on the bench going on 3 years.
Going on 3 years, okay. And so this Ask the Judge segment with Judge Rebecca Bradley will allow our listeners to call in after 3:30 p.m. with questions as relates to the topic that we're dealing with. We know there's a lot of folks who have engaged the court system, and sometimes we just don't know what to do or what certain things mean. And so today's session will allow us to answer some of those questions specifically. Now, one thing we cannot do on this show is give any legal advice to anyone, but we do recommend that you seek out an attorney or some other legal personnel to present your concerns to, or to represent you, or to guide you in terms of what your options are as it relates to your cases. On today's show, we're going to do a couple of things. One is we're going to start out with a closed conversation from now until 3:30, and then prepare to call 414-444-5250. We particularly want to kind of explore the relationship between fathers and the dependency court and family court, if possible. And our main focus is going to be on the dependency court, or CHIPS, as they call it in Wisconsin, which is children who are in need of protective services. And so first, we want to identify historically and culturally how courts view fathers and mothers. Second, explain what the difference is between family court and dependency court. Third, define some legal terms. Fourth, we will find out whether the courts and child welfare have contributed on some level to children growing up without fathers. We'll touch on that a little bit. And then the last thing is to make sure that we can really outline what the dependency court process looks like in Wisconsin. I really want to spend a lot of time on that whole process, and then also how fathers are engaged or not engaged in that process. Okay, so are you all ready for the conversation? Absolutely, great. Well, the first question I'm going to ask you is can you talk about what is dependency court versus family court?
And there's a lot of confusion in that area, even among attorneys who don't practice in these areas. So in Milwaukee, family court handles divorces, separations, paternity matters, child custody, child placement, and I also want to draw the distinction between custody and placement. Custody is the right to make decisions for and about the child, major decisions, and placement refers to the amount of physical placement or time that each parent has with the child. So there's a difference there. For example, a parent could have placement or time with his or her child but not have custody. the standard is usually 50-50
50%.
shared custody, not the case always with placement. So children's court, nationally referred to as dependency court, children being dependent on the court system, we call it children's court in Milwaukee. Those cases involve child abuse and neglect, termination of parental rights, guardianship, adoptions, and juvenile delinquency.
So now you said it covers guardianship, adoptions, delinquency. So what is guardianship versus custody and placement?
Okay. A CHIPS case comes into court usually, but not always, because the state of Wisconsin is bringing the CHIPS case saying we have a child or children who are in need of the protection of the court and the services that the court system can provide. Sometimes a guardianship case is very different. That can come into court because there's a concerned family member, extended family member or grandparent who thinks that parent or parents aren't doing a good job with their child, or there's something going on in their lives. Drug addiction is an issue all over the state, for example. So grandma or grandpa will come in and say, I think you should appoint me as guardian to the age of 18.
Okay.
Parents keep their parental rights, but if a guardianship is put in place, then the guardian has the right to make decisions about and for the minor children until the age of 18.
Okay. So you mentioned that you've worked in children courts for 2.5 years.
Yes.
What are some of the judges or the type of judges or courtrooms, I don't know how you want to term it, that are located out at Children Court Center?
Okay.
Or do all the judges do the same thing?
No, all the judges do different things. There's 8 judges at Children's Court. There's a presiding judge, and she, right now it's Judge Trigiano. She handles a smaller caseload because she has a lot of administrative responsibilities, and she also presides over Family Drug Treatment Court. The other judges, there's 2 who handle full-time termination of parental rights cases and adoptions only. The other judges all have a split calendar of juvenile delinquency cases and then the CHIPS cases, or the child abuse and neglect cases. On top of that, they'll also hear guardianships and some other matters.
Okay. So if we can kind of talk about for the next 10, 15 minutes or so, what does that whole dependency court process looks like from start to finish? What happens when a child is removed, what to do if your child is removed, the first court hearing, what do we call it here? I don't know if it's a detention hearing or...
In court, we informally call them emergency detention hearings.
Okay.
The emergency part comes from the fact that we statutorily under the law a judge has to hear the case within 48 hours of a child being removed from his or her home.
So let's start with the phone call that's made to Child Protection Services indicating that possibly there's been abuse or neglect of a child. So it starts there. Then what happens?
Okay. The Bureau of Milwaukee Child Welfare, or one of the agencies that they contract with, will do an investigation, and there's probably other people can speak better to what happens kind of behind the scenes, but I'm going to jump right into talking about what happens from the court system perspective. An assistant district attorney who is assigned to children's court will generally meet with that social worker, review the paperwork that the social worker presents, and then determine whether under the law there's a case that should be brought before a judge. So if the child is removed by the Bureau, sometimes law enforcement's involved, can be extraordinarily traumatic for the child regardless of the situation. But a hearing must be held in front of a judge within 48 hours. I should have mentioned, there are also court commissioners who help the judges out. They have more limited powers, but they can hear cases at children's court to a limited extent as well. So what happens when the judge gets this paperwork? The judge reviews it and determines whether there's probable cause to believe that this child is in need of protection or services. There's a hearing that's held. The parents show up in court. They are routinely appointed an attorney. Each parent who's involved gets their own attorney. Many of the parents who come into children's court are indigent, so they qualify for the appointment of counsel at county or taxpayer expense. The children also get an attorney or a guardian ad litem appointed for them.
And that depends on their age.
Correct.
Okay.
Correct.
So what is the age there? Is it
The cutoff is 12. If
Okay.
the child's under 12, the child is given a guardian ad litem, who usually is an attorney, always an attorney actually, but that person represents the best interests of the child. If the child's over 12, the child gets an attorney from the state public defender's office, and that attorney represents the child and what the child wants. So the hearing comes before the judge. The paperwork is looked at in advance. The judge hears from the attorneys. And if the parents, when I was in children's court, if the parents wanted to tell me something, I would say to them, you might want to run that by your attorney first before you say anything to me. But I would give them the opportunity to speak, and depending on the age of the child and the comfort level that I sensed, if the child wanted to talk, would certainly hear from the child as well. But at that point, the judge isn't making a determination as to whether or not the facts alleged in the paperwork are true or not, regardless of what they are. The judge looks at the paperwork and determines whether it says enough that there's probable cause to believe that the child's in need in some
And how do
respect.
they determine probable cause? I mean, is there a criteria or a guideline that is used to say, okay, well, we have a medical record right here that shows bruises or what have you? I assume that would be probable cause, but
Right.
can you
You-
speak to that?
Usually the paperwork isn't as detailed. It's
Okay.
prepared by a social worker from a number of reports that have been received and investigated, conversations that are had. I don't want to compare it to a criminal case, but sometimes it's easier for people to understand
Okay.
from that perspective. These are not criminal proceedings, they're civil proceedings. So the
That's
parent,
important.
yeah, it is. It's a very important distinction, but the probable cause finding, people hear that more often in a criminal case. So like a criminal case, somebody's charged with a crime. At the first instance, the judge isn't deciding whether the person committed the crime or not. They're looking at the complaint
Okay.
and looking at it and saying, is there enough alleged here that if it's true, this person likely committed this crime?
So since you brought up the point that this process is more of a civil complaint or civil proceeding versus a criminal proceeding, a lot of times we hear the term that a child protection service worker is doing an investigation. So when we use the term investigation, that has a tone of being a criminal something. So maybe the word of an assessment or a review is a softer word because
Yes.
it almost sounds criminal when we use those terms.
And I'm probably talking from more of a lawyer and
Okay.
judge's perspective. The social workers have their own vernacular,
Okay.
probably a little friendlier to the people involved. But you're exactly correct. There is an initial assessment caseworker from the Bureau
Yep.
of Milwaukee Child Welfare who looks at it in the first instance. Others get involved to do interviews of people. I'm avoiding the word investigate
Okay,
now.
great. So we've talked about this hearing that takes place within 48 hours, and both parents involved, or is it just the let me just say the legal guardian or custodian of the child that typically, or the person who the charge is made against? Should both parents be at that 48-hour hearing?
Should all parents be there? Absolutely. But what often happens with families who have child protective services involved in their lives, unfortunately, a lot of these are single parent families.
Okay.
A lot of them are single mom families.
Okay.
But whomever was involved in whatever the situation or situations were that brought this case into court, those people usually come to court. Sometimes there is an absent father or an absent mother. No one knows where the person is, or they can't get a hold of them. Efforts are made to make sure that the parents are there, but sometimes it's only one. If the child has a guardian, guardians are subject to these proceedings as well. So it could be the case that it's the guardian that has an assessment being done of what the situation was that brought the family to court.
For those of you who are just now tuning into this program, you're listening to Fresh Start Today. I'm your host, Jermaine Reed, and this is our Ask the Judge segment. We will be opening up the phone lines at 3:30 p.m., and you can call 414-444-4 5250 444 5250. We'll be right back after this break.
Hey, this is Jermaine from Fresh Start Family Services. Did you know the absence of a loving, nurturing father can wreck the lives of children? Unfortunately, millions of children and youth grow up without a healthy connection to their fathers for a number of reasons: abandonment, unemployment, incarceration, death, etc. When compared to other children, foster children are at greater risk of not being fathered. Fresh Start Family Services is looking for a few honorable single or married men to become licensed as foster parents. Research supports that children and youth in our community need one caring, supportive adult in their lives to take them from being at risk to at promise. Men, our future is in our hands. We can make a difference in the lives of young boys today. To learn more about how you can become licensed as a foster parent with Fresh Start Family Services, please call 414-351-1100. That is 414-351-1100. Foster the future. Foster a child.
Good afternoon. You're listening to Fresh Start Today. I'm your host, Jermaine Reed, and we have our Ask the Judge segment with Judge Rebecca Bradley in the studio today, Dr. Ramel Smith and Sean Roby, and we're talking about fathers' relationships with family court as well as dependency court, and we were just going over what the dependency court process looked like, and we kind of ended with the first hearing. So what's next after the first hearing, Judge Bradley?
After that first hearing, and assuming the judge found probable cause, so the case is going to continue, the case is set usually about 30 days out for what's called a plea hearing. At that hearing, the parents come back and the child comes back. Sometimes they're not in court, though, for very good reasons. And they tell the judge whether they want to admit to the allegations in this civil complaint that, yes, their child or children are in need of protection or services, or they're denying it and they want to go to trial. So then the next series of hearings are set. There can be a settlement conference, usually in front of a court commissioner, where the court commissioner sees if there's some way that we could come to an agreement about where this case should go, or it's set for a trial.
And who's at the settlement agreement again? What parties?
Conference.
Yeah.
All the parties would be there.
Okay.
So if we have mom and dad both involved, their attorneys, the guardian ad litem or the advocate counsel for the child would be there. Parents should be there. Again, children, depending on their age and what the situation is, may or may not be there.
Okay. What happens after the settlement conference?
After the settlement conference, if the case is able to be settled, it goes to what's called a dispositional hearing. And at that hearing, the court will, with input from all the parties, basically enter an order saying, here's what you need to do to resolve this case. Here's what you need to do to get your children back in your care.
Okay.
It can be a whole variety of issues. We have parents with substance abuse issues, parents who weren't raised very well and don't know how to raise their children, so they need some services to learn, like parenting classes.
Yeah.
A lot of mental illness in the children's court system, so services are provided along those lines. Whatever the family's needs are, and it's looked at from the family perspective. Often the children have their own needs because of what they've been exposed to or how they've been raised. So services are put in place for everyone who needs them, and the parents are given specific goals to meet that will be overseen by social workers to get their kids back in their care.
So those are court order conditions that they must meet. And what are some examples of court order conditions? It could be parenting classes, as you mentioned.
Parenting classes.
Alcohol and other drugs.
AOTA assessments.
Right. Anger management
management,
classes.
therapy.
And also, we often hear about finding suitable housing.
Yes.
And
that brings up an issue I wanted to briefly mention. A child cannot be found in need of protection or services just because parents are poor.
Okay.
What
That's
happens
important.
before it ever gets to court, if there are some issues where there just isn't enough money in the house, social services will come in without court involvement, sometimes because a neighbor calls and says, hey, these kids are knocking on my door hungry every day. I think you should look into this. Whatever the case may be, services are attempted to be put in place so that it doesn't get to the point of the children being involved in the court system or being removed from the home.
And I was going to ask Judge Bradley, can you give an example of this? Because I guess to raise the confidence of the people, we had talked about sometimes the court system being somewhat adversarial to the families. They seeing them that way. So they say, yeah, you say you're going to help, but they think it'll be actually more detriment. Can you give an example to say, hey, this is a way we've shown that we can be helpful to families?
Well, as a judge, when I was in children's court, one of the most important things I looked at in all this paperwork that's being presented and in the arguments that are being presented, what was done to prevent the children from being removed from the home? What services were offered and provided, and why didn't they work out? There are a lot of situations, families who have social service involvement in their lives who never end up in court because they got the services they need. But courts definitely look out for the rights of parents and the children to remain as a family unit and not have unnecessary court involvement. And there are a number of cases that go into children's court and the complaint is filed saying children are in need, and a judge will reject that by saying this is not a situation that requires court involvement.
Okay. This issue around fathers and their rights in courts, can you kind of, independency court, can we talk about what rights do fathers have in the courtroom?
Well, one issue that I ran into in children's court is that we have a lot of dads who didn't marry mom, and they never became adjudicated as the father of the child. And they don't end up with no rights in court, but they have less rights than they would have if they had gone to paternity court, family court, and gotten adjudicated as the father. So what happens is we have situations frequently where a father is alleged to be the father.
Okay.
And everyone may know that this man is the father,
okay,
but a DNA test is done, and then a process of adjudicating the father can be started again in paternity court. But the father has less rights when he's alleged. When the
okay,
father is adjudicated, he has more rights. So, unfortunately, there are situations that end up in children's court that don't need to end up there if the father had been adjudicated, because then he could assert his parental rights.
What do you tell a father who's under that situation, but he did not sign, he was not adjudicated as a father because it would have been a statutory rape found out, but now a situation has come up where the child is in jeopardy, but they may be afraid of some of the other consequences from that initial relationship?
I again, can't give legal advice, but I would say this. It's really important for dads to step forward, and I want to say this to all the dads out there who might be in this situation. Fathers are very important in children's lives, and when the dads aren't there, the children feel it acutely. I've seen it over and over again. So I would encourage dads in these situations to talk to social workers, talk to their pastor, talk to somebody about the situation so that they can get led on the path of what they need to do to fix that situation, and always talk to an attorney when there's complicated issues like this that could involve the criminal courts.
Well, for those who are just now tuning in, you're listening to Fresh Start today on WNOV, and we're talking about fathers and their relationship with the courts. And we have in the studio with us today Judge Rebecca Bradley. And so if you'd like to join this conversation, please call 414-444-5250, 414-444-5250. The lines are now open. The question that I have, you mentioned about alleged father. So what is a presumed father? Because it's my understanding there are different groups or categories of classification of fathers. One is being alleged, the next is biological, and then the presumed father. So what is the presumed father?
If we have a married couple and a child is born, the father who's married to the mother is presumed to be the father. That can be rebutted, of course, in various situations.
Well, what about a father whose name is on the birth certificate, but there hasn't been any blood test or anything done? Is that a presumed father?
That's a good question.
Okay, I'm just wondering if that's
I'm not sure about
because
that.
Because if somebody showed me a birth certificate of Jermaine Reed and is John Reed on there, I probably would presume, just by looking at it, just anybody on the street, I'll just presume that that's who your daddy is.
Yes, I think there are situations where the mother can put a father's name on the birth certificate by just saying that's the dad.
Oh, that's been done. That's been, trust me.
It
that's
happens.
been done.
So,
and then 10 years later, you find out,
It
guess
happens.
what?
so for
Right.
court purposes, that's not enough.
Got you. All right, so
I think to add, what you mentioned, and Dr. Smith as well, when you talk about, I think just the whole idea of court, it makes people nervous. So when you talk about dads and their rights and things like that, I think this is so important because there is help out there to prevent people prevent people from having to get to that level of court. And so that's something that we all have to keep in mind, that if there's anybody in your corner, and I think you mentioned pastors, friends or family, you know, just talk to somebody. And you can always reach out to like 211 or 411, and they can guide you into some directions as well.
Well, now, you know, all courts, I guess, family court, let me just speak of family courts, and also CHIPS or dependency court, should be working in the best interests of children. You hear that term often, you know, and not just in the court system, but in child welfare system as well. So what do you all mean when you say we're working or in the best interest of children? Is there statute around that, or is that just something that people come up with? Can we talk about that?
It depends on the type of case, but for example, the Children's Code is Chapter 48 of the Wisconsin statutes. I'm throwing it out there because I know people like to Google and look things up, and there's lots of law available on the internet. But it's not a defined term under Chapter 48. And so as a judge is going to look at other parts of the statute. What does this mean? What did the legislature intend? And so I would look to the legislative purposes underlying the Children's Code. And under the Children's Code, the paramount goal is to protect children. It's also, there's a number of other goals that are looked at, like preserving family unity, strengthening families when it's possible, when it's appropriate, helping parents fulfill their responsibilities. But courts absolutely have the authority to not reunify children with their family, and the legislature has said that instability and impermanence in family life is contrary to children's welfare. And so there are time limits, depending on the case, under law that require the court system as a whole to work toward reunification, but after a certain period of time, children need a permanent home, and that's when alternatives are looked at. Not always termination of parental rights, but long-term placement, sometimes with other family members. The problem with that is that even that is not that permanent. Which is why adoption sometimes is favored. It depends on the facts and circumstances. I will also tell you that there is a common sense element to it. There are some really extraordinary cases of terrible abuse and neglect where, there's going to be some effort made to help a parent get on a right path, but some of those parents end up in prison for decades because of what they've done. So at some point, common sense comes into play. What's in this child's best interest? Well, you got to look at all the facts and circumstances of this child's life in weighing that. But judges should be looking at the law and the legislative purpose, because that's where we get our direction from.
So you've mentioned about this federal guideline with this federal timeline. Are you referring to the Adoption Safe Family Act?
Yes, we are bound by that.
And so what is the time period if your child is in out-of-home care for 15 consecutive months out of 22, I believe it is,
Yes.
then the county or whomever has removed that child from those parents' care have to file a petition to the court to
terminate parental rights.
A TPR.
But there are a lot of exceptions.
And those exceptions, what are those exceptions? Because you mentioned common sense.
Right.
Was that one of both? Do we know what some of these other exceptions are?
If it's not, I hate to go back to an undefined term, but if it's not in the best interest of the child to terminate parental rights, there could be really good reasons not to. For example, we have a 17-year-old child who's about to enter in adulthood, and child's living with a family member and is happy and doing well and thriving. Why terminate parental rights, right? There isn't always a reason to do that. So that's one exception. But the best interests of the child are always looked at in making those determinations. But having said that, the social workers who make these recommendations about what should happen next have to give a really good reason, because we are bound by federal law. Judges have leeway, they have discretion, but we've got to follow those time limits.
Now, I have a question, because a lot of these cases, unfortunately, once they're in the court system, these families seem to stay in there for a long period of time. However, the judges usually rotate like on a 2 or 3 year rotation. Why is that within the court system to have I guess sort of like a lack of stability within the judges, knowing that they would know these cases and then new judges have to learn them and become familiar with them?
And I guess how does that impact families?
Yeah.
That's a great question. And actually, there's a lot of conversation about that nationally, and there's a movement toward having one judge for one family,
Okay.
so that children's court and family court wouldn't be so separate. So if you have a couple that's divorced and they have ongoing custody and placement disputes, but there's something else going on in the family's life, like the juvenile is adjudicated delinquent of a crime, or there's a CHIPS action, that one judge would hear all of that. In Milwaukee, there are 47 trial court judges split across multiple divisions, and it has been, as long as I've been in the legal profession, for the last 20 years, and before that, a rotation system. It's unfortunate. I actually rotated within children's court when I was there, from CHIPS and delinquency to TPR. I hung on to some of my CHIPS and delinquency cases because I thought in that circumstance, if the parties wanted me to stay on, that it was important for that family to have that continuity. But it's difficult in the system for families who get to know and get a comfort level with their judge, because it isn't always adversarial, even with the prosecutor involved and the state public defender's office. Oftentimes, with a lot of these cases, it's a very collaborative approach, and everybody, including the judge within the parameters of the law, is looking to help this family out, whatever that means for that family.
Now, is that rotation, is it 2, 4, or 6 years?
It varies. The standard is every 4 years, but sometimes a judge retires, and all new judges have to go to children's court or misdemeanor court. So as a new judge, I went to children's court. So that's going to create some disruption as well.
So let me ask you something, because you've mentioned earlier that a number of children who come into care are living with a single parent mother. But these children have multiple siblings, 2 and 3 and 4 different brothers and sisters, and sometimes they don't have the same fathers. So does that create any type of problems, or how does the courts deal with that, especially around the siblings relationships, or what's in the best interest of children, fathers' rights? Does that complicate matters, or is there a way that you all deal with that?
It complicates matters, but we do try to deal with it. I'm talking like I'm still at children's court. I'm on the Court of Appeals, but I left my heart in children's court. I loved it there. We tried, and the current judges and the whole system try to keep siblings together. That's a primary consideration. But when there's more than one dad, it makes it really tough, because oftentimes relatives step forward and say, we want to take these kids, but they can only take 1 or 2, or they only want to take the child that they're related to.
Yep.
And that, they're good people, but they can only do so much, or they don't even know this child.
Right.
So it complicates matters greatly, but everyone in the system, I think, really strives to keep kids together. It's tough, though. I mean, if you have a family of 7 kids, it's really hard to find a family member who's willing to take all 7 of those kids.
And so, kind of relating to that question, what are there for like sibling rights, for grandparents' rights, for those who maybe say, you know what, I don't want custody, I can't do it financially or for health reasons or whatnot, but I want to maintain a relationship? How does the court help to maintain those healthy external family members' relationships?
The tack I took was that it's always best within families if the families can work that out among themselves rather than having a court dictated. And so when issues like that were presented to me, I would say, you know what, I could listen and then tell you how it's going to be, but no one's going to be happy with that. And you all have to get along and work in the best interest of the children, again, and set aside your own issues with each other and just think about the kids and work it out, because if you can work it out, that is the best thing for the kids, not to have a court dictate it.
Now, the reason why I ask is working at Children's Hospital, we would have a kid adopted, and then sometimes the adopted family wanted to remove all
ties and
dealings with
connection,
that family for multiple reasons. So how would you intervene in that when you see like these extraneous circumstances that's going on, where you say it may be in the child's best interest for the court to intervene in these matters?
There isn't a lot in the law for the judge to look at and say, I can give rights to people in these situations. Grandparents have rights when one of the parents dies, okay? Then the grandparent or the parent of that person who died has some rights to see and be with the minor children, and they can assert those rights. But if the parents are alive, they have less rights. So it really tends to happen on an informal basis, but sometimes mediation can be ordered. So somebody comes in with a fresh set of eyes who doesn't know all the people involved and sits down with them, literally sits down with them in person in a conference room and hears from everybody and tries to work it out. On that note, though, it's interesting. There's the Indian Child Welfare Act, a whole different issue.
Yeah.
They take a different approach when rights are terminated, the parents' rights are terminated. It doesn't terminate the biological family's rights. Very interesting distinction there.
Let me ask you this question. Let's just say a father was not engaged in a court proceeding or the process, and their son or daughter is up for adoption or have been adopted. Can they reverse that adoption if they can prove that no one really tried to engage me or to connect me to this court process? Are you aware of any cases or court?
I'm not sure of any case precedent for that.
Okay.
I think it has happened, but that person in that situation needs to get a good attorney to address that situation. At the outset of termination of parental rights proceedings, there is an obligation to make efforts to notify the biological parents.
But that's more work for the case manager.
It's work, and that's a tough call because now we're looking at reasonable efforts. Is that a letter
you
to the
define
last
that,
known
reasonable?
address? Is that reaching out to mom? And mom, if she's upset, she's going to tell you nothing or just send you on a wild goose chase. So you have all these different dynamics.
Because I know of cases where the father became engaged in the process way down the road. Let's just say at the 17th month, right, the 18th month. But this child has been placed with this other family. They've bonded, they've connected. There's actually been court cases where fathers have fought the system to try to get the child to be with them, and said, no, we think we've identified this adoptive resource over here. So in situations like that, we know it's always best for fathers to be engaged in the front, but things happen where folks are not connecting with fathers. So what rights do fathers have, whether it's at the 17th month, or do we start the process over and say, hey, let's pump the brakes here. I understand federal guidelines, ASFA and whatever, but I was not engaged. There was not reasonable effort made, and I can care less about how long my son or daughter has been over here in these folks' houses. Right. What are my rights? What can I do? An attorney, you talk about a good attorney.
See a good attorney. First and foremost, you'll hear that from me more than once this afternoon. But at the outset of a termination hearing, it's not just efforts. It's defined in the statute what has to happen, but it's kind of weak. I mean, basically, the father has to be personally served at his last known address.
Okay.
So even if we know that's not where he lives, service has to be made there. But attempts are made beyond that, and it's really, the judge has some responsibility here to ask, okay, what did you do to find Dad? What do we know about him? Where might he be? Who might know where he is? Okay. Sometimes they have a phone number for him, and he won't answer the phone. I've picked up the phone in court in the middle of a hearing to try to get a hold of Dad. Sometimes they answer. But the judge has some responsibility there, too.
Okay.
But the law is relatively weak about the efforts that need to be made. And sometimes there's a mother who, for whatever reason, sometimes it's a good reason, sometimes it's a not so good reason, isn't helping to find Dad.
And I know some time ago, being on the Engaging Fathers Committee with the Bureau, and that was one of the things that we always talked about was, can they implement something into WSACWIS, which is the Electronic Wisconsin Access System for Child Welfare? Could they have an asterisk in there where if they have not identified Dad or Dad's whereabouts, like they cannot move past this point in the case in their electronic system? And so we were just thinking about different ways some time ago on how to get fathers engaged. And I know that was several years ago, but more as of the recent history, they've generated new fact finding or father finding or family finding programs to assist in finding that other parent.
And that's been helpful because letters are sent to family members, extended family members, about the case when they're looking for placement for the children, but that's often a good way of finding dad or getting a hold of him. The intervention of his own family members sometimes will get him to come to court, or the family members will show up in court. And when I was in children's court, I would ask family members who showed up, do you have any way for us to get a hold of dad?
Let's say mom is not being cooperative, because that happens in some cases, and here's a paternal aunt or a paternal grandparent. And can they just call the Bureau of Milwaukee Child Welfare, contact the courts if they know that maybe that child is in custody to say, I want to be able to be considered to take placement of my nephew or my niece?
Absolutely. And I know that the Bureau of Milwaukee Child Welfare social workers are overwhelmingly busy, and they can't always or don't always get back to people right away. And if the family members want to make sure that they stay involved and get involved in the child's life and in the child's case, they can show up at court, because the social workers have to come to court for the hearing so they can get in direct contact right then and there.
So what do we do for that father who's unfortunately incarcerated? He understands exactly what's going on, but he can't do anything because of his situation. He understands he will be out in a certain amount of period of time where the child will still be a legal minor under his guardianship. How can that father be helped?
The incarcerated father or mother, because we have instances of
Very
both,
true.
certainly, they are still subject to the order. So they will oftentimes participate in the proceeding. Sometimes they elect not to for whatever reason, but they are usually appointed counsel, and the order will have terms and conditions for them to meet. While, for example, while they're incarcerated, they can participate in parenting programs and other programs. They can stay involved where it's appropriate in their child's life with telephone calls, sending letters, and that's really important too. I can't imagine how some parents who are incarcerated feel so separated from their children, but maintaining that contact where it's appropriate for the child and good for the child is very important for the child.
That's good. We're going to take a break. You're listening to Fresh Start Today. I'm your host, Jermaine Reed, and you're listening to the Ask the Judge segment with Judge Rebecca Bradley. We'll be right back after this brief break.
Do you know what Nelson Mandela, Andrew Jackson, Malcolm X, and Steve Jobs have in common? Each of these individuals were world leaders who were once in foster care. We often hear about the road from foster care to prison, but did you know there's another road from foster care to a world stage? Fresh Start Family Services is looking for adults to become licensed foster parents. Every child needs a caring adult in their lives. Wouldn't it be great if you could foster or adopt the next world leader? For more information on how you can become licensed with Fresh Start, please call 414-351-1100. That is 351-1100.
Good afternoon. You're listening to Fresh Start Today. I'm your host, Jermaine Reed. You're listening to our Ask the Judge segment with Judge Rebecca Bradley and Dr. Ramel Smith and Sean Roby. And listen, we have about 11 minutes left to this conversation. If you would like to join, please give us a call at 414-444-5250, 414-444-5250. And you can join us on the internet by going to WNOV860.com and click on Listen Live. You can watch previous shows on YouTube by searching for Fresh Start Today. Now, you brought up the term about good lawyers, that you kind of look for good lawyers. And I assume when you talk about good lawyers, Judge Bradley, you're talking about lawyers who present, who are responsive, who are competent, who are compassionate, all of that kind of good stuff.
Call you back.
Call you back. Because I think some parents, mothers and fathers who are in dependency court, sometimes they're struggling with the fact that my case manager's not calling me back because they're busy. My attorney is not getting back to me. I don't have a voice. I don't have anybody to speak on my behalf. And then they're meeting with us the night before court, or the guardian ad litem is trying to reach the foster parent to get to the foster. How does that impact what goes on, decisions that are made in the courtroom? And then we're going to take this caller after you respond.
Well, this is a great question and a great topic, because sometimes the judge will get the sense that everybody's coming into court, they just talked for 5 minutes and the case has been out of court for a month or something, or some length of time, and we get the sense that, gosh, people aren't talking to each other, what's happening? So we'll initiate a conversation about that and try to rectify it. Everybody's really busy. The system is absolutely overloaded. But that's where it's important for the parents to not be afraid to let the judge know, sometimes it's uncomfortable because your attorney's sitting right there.
There's a lot of power in that room.
Right. But if the parent can say, I'm just not communicating well with my lawyer, or my lawyer isn't calling me back, let us know that. A lot of the attorneys are appointed in children's court. Parents sometimes hire their own. The price on the attorney per hour doesn't mean the attorney is going to be a good attorney. It's important to have somebody who has experience in children's court, who understands the system and will be a good voice and good advocate. But judges, I think, do try to step in to ask the parents, do you have any concerns, any issues, anything on your mind that your attorney hasn't mentioned? I know I always did that when I was in children's.
I'm going to have to keep my eye on Judge Rebecca Bradley, because she's running for the Wisconsin Supreme Court. So I want to wish you well on that campaign trail, and thank you for this information you're providing today. Caller, you're on Fresh Start today. You have a brief comment or questions?
Yes, and I thank you for taking my call. Hello, everyone.
Hello.
Hello.
This is a wonderful discussion, and I'm looking forward to more of them. I'm just curious if there's been any inroads made in sort of fleshing out parental alienation. I know that's a hot button topic, and that's something that I was dealing with. I filed a motion to change order, and was in family law court for 4 years, and then lost terribly. What happened to me was I got everything but a TPR, so that I was still mandated to pay child support. But my son is out of state, and his mother remarried a Mormon fellow who they used the Mormonism, all non-believers, to drive a big wedge between me and my family and my son. And by the time we got to court, he was saying he didn't want to see me, he didn't want anything to do with me or any of us. And the judge didn't really want to hear anything about the religion or using the Mormonism, to drive the wedge. And my son just turned 18, but he's still in high school till. He's still a senior. She held him back a year, so I still have to pay support till this coming May. But I don't see him. I don't talk to him. As soon as the ruling came down, she blocked my number. So all I can do is write him letters, and he doesn't have to talk to me or see me if he doesn't want to. But I still have to pay the money. And I never minded paying the money. It's just I thought I would get what's fair. And the judge couldn't come up with any good reason as to why he put the order in place as he did, other than that the child didn't want to see me. But he didn't show any good cause for that. Having contact with me would be harmful for the child.
All right. So do you have a quick question for the judge?
Has there been any inroads to sort of flesh out more about parental alienation and on religious grounds, or using religion to sort of mentally abuse the child and drive that wedge between custodial parent and does that make sense?
Okay. Yes, sir. Thank you for tuning in to Fresh Start today. We're going to have the judge answer the question. We also have another caller on. We're going to get that question, then just have you answer both of them. So one is dealing with parental alienation. Caller, you on Fresh Start today? Do you have a brief comment or question?
Yeah, my question is just I wanted to know how or is it possible for somebody to be put on the birth certificate as a guardian or a parent, and you don't know this person, but yet and still, is there a process that you can get them taken off also because you never received child support?
Okay, thank you.
Thank you.
I'll answer the last question first. I think the question was, is there a way to remove a guardian who's been appointed? And there is a process for that. Again, consulting with an attorney is important, but you could also go to children's court, and the administrative staff there can share the paperwork that needs to be filed. But there is a statutory process under the law for reversing a guardianship that's been put in place. The question about parental alienation and the religious aspects of that is really a policy question. I'm not aware within the state of Wisconsin of any initiatives from the legislature addressing that particular issue, and it would be really difficult for me to comment on, and I really can't comment on the gentleman's particular case, as I didn't preside over it and I don't know all the facts underlying that. But it's something I know in children's court that the judges are cognizant of and aware of, to make sure that parents who are, whatever the situation is, physically separated from the child, that they still have the ability to communicate again when it's safe and appropriate for the child.
You know, I think along those lines, if a parent, they would like a new attorney assigned to their case or a new judge, they have that right, though.
Yes, there's time limits in place under the law. It pretty quickly have to decide whether you want a new judge. I talked about a plea hearing in the Chips case. You have to ask for a different judge, and you don't have to give a reason. If you walk into court and you just don't like the person sitting on the bench, you can ask for a new judge, although consulting with your attorney is really important. And judges who have appointed a counsel to represent a parent will appoint a new counsel if there's a good reason for doing so, but you can't keep asking for a new attorney, right? Because that's not good for anybody. It's not good for the case, the children, the people involved, because it delays things. Somebody new has to get up to speed. But again, absolutely, if a parent has an issue, they're not working well with the attorney, I think judges will be inclined to get a new one for that person.
You're listening to Fresh Start Today. It's been great. We had Judge Rebecca Bradley on with Dr. Ramel Smith and Sean Roby for our Ask the Judge segment. We hope that Judge Rebecca Bradley will be able to come back and join us in the future.
I would love to.
Want to wish you well on your campaign, your journey to the Wisconsin State Supreme Court.
Thank you very much.
Thank you very much.